How exactly is a DUI defined under Florida state law?
There are two ways for the state to prove a DUI in the state of Florida. The first way is by showing that a person was driving with a breath or blood alcohol concentration above 0.08. If a person was above that level, then they will be considered guilty of DUI regardless of whether they were actually impaired. The second way to prove a DUI case is by showing that a person met the statutory definition of DUI, which means they were, quote, under the influence of alcohol to the extent that their normal faculties were impaired, unquote. This is sometimes called the common law DUI. In a common law DUI case, based on all available evidence, including video footage, audio recordings, and any admissions made, jurors will decide whether or not someone met the definition of DUI. This means that even in the absence of a valid breath test result showing the breath alcohol concentration above 0.08, the state can try to prove beyond a reasonable doubt that the defendant was under the influence of alcohol. For example, if a person admitted they had consumed a whole 12-pack of beer, they might be proved guilty of DUI beyond a reasonable doubt, regardless of whether they passed the field sobriety tests or were even actually impaired at all.
Tom Hudson is widely respected for his training and knowledge of the field, as well as his decades of trial experience. The Hudson Law Office has represented thousands of citizens accused of crimes for over 30 years.